All right, good afternoon, members. I will call Committee of the Whole Bill 31, Emergency and Disaster Management Act, to order. We're on Clause 1, and I think we're member for Caribou-Chilcotin is up.
Well, thank you very much, Chair, and it's nice to be in the room together. We do have a few more questions on the definitions, Clause 1, and my colleague from Vancouver, Langara, will be joining us just as notice to the Chair to kind of keep a watch out there on Zoom. But I'll start with, I'm going to pass over the term head. As the colleague, as my colleague does have a couple of questions on that term. But I want to move along to local knowledge, and I want to get a bit of a better sense of what the term people will refer to in that.
Minister.
Thank you so much. So we have not restricted or limited the definition of people in any way, and so it does carry its ordinary definition, people, you and I, or the member and I. But for the purposes of providing greater elaboration on the definition of local knowledge, I'll offer that local knowledge is considered to be separate from Indigenous knowledge, although the two can share similar characteristics. So maybe that's a bit of a helpful elaboration.
Thank you very much. As we found out last week, the typical definition of person is a little bit more complicated than we expected as well, and I think we'll have a bit more conversation about that today. I guess the reason that this is important is that so many individuals in certainly ridings like mine or others have wanted to really be involved with sharing information, not necessarily just about how a response to a fire or a flood may happen, but certainly with respect to preventative measures as well, which we've talked quite a bit about. And so I guess that's why I just wanted to get an understanding of, who we might be looking for, when we might be looking to have that conversation, and certainly what might be contemplated as far as a mechanism to chat with them. Now, we can chat now or we can chat under Clause 2, but I think it's Clause 2, I can't remember. But frankly, I know that a lot of people want to weigh in on these conversations, and I'm just trying to understand exactly what the ministry might be contemplating when it's talking about this. I mean, I can presume, I suppose, but I'd love to hear it from the minister that we would be talking about ranchers and guide outfitters and people that have vested interest in our land. But might that also include other tenure holders? And so I can appreciate what people might generally mean, Mr. Chair, but I want to be clear about what we're referring to in this definition. Thank you.
Minister.
Thank you so much. So the short answer is yes, absolutely. Ranchers would be an example of people that might be involved in providing local knowledge. So as an example, farmers sharing their experiences on seasonal flooding that they've observed over time as they've been farming their lands. And the point of time at which this kind of local knowledge would be incorporated into emergency management work we can discuss that under Section 51, which is risk assessments, but kind of gives you a little bit of a prelude that under the assessment of risk, local knowledge would be one of those areas of expertise that are incorporated into risk assessments.
Member.
Thank you very much, and yeah, we'll come back to that a little bit as we traverse through the clauses, just to get a better sense of how that engagement might occur and how that might look. So we will come back to that. Just very briefly, necessities. I get the three necessities that are here, but I was actually surprised that there wasn't more defined under that term, and so. We've defined, or rather the bill defines food, clothing, and shelter. I can appreciate that those are all necessities, but was there anything else contemplated here? Medical, transportation, all the other things that we would obviously need in our times of need, and why wouldn't they be listed here?
Minister.
Thank you so much, Chair. So in this case, the definition of necessities, it is an inclusive definition, and so it includes the ordinary meaning of necessities and food, clothing, shelter. So it's to provide assurance that for certainty, necessities certainly does include food, clothing, and shelter, but is not intended to exclude other forms of necessities that might be defined through the ordinary meaning of the word necessities.
Member for Caribou-Chilcotin.
Thank you, Chair. I have one more question on the term security threats, and then I believe Vancouver Langara will be taking us back to the term head. where he'll have a couple of questions on that as well. With respect to security threats, again, it's pretty clear that this actually refers to the impairment of government or society. I'm guessing that that would include things like destruction to infrastructure and things like that. Yes or no would work on that?
Minister.
Thank you so much. So for greater clarity, it could, the term security threat, it could include actions that, that destroy infrastructure. However, that destruction of infrastructure would have to severely impair the functioning of government or society. So the mere destruction of infrastructure in and of itself may not meet the test, but if that destruction of infrastructure severely impaired functioning of government, then it could.
Member.
Thank you, Chair. I think we're going to move to Vancouver Langara now. If Michael could give a signal that he can hear us. And
Member for Vancouver
Sorry.
Langara, you good to go?
Yes.
Go ahead.
Oops.
Got the floor.
Thank you, Mr. Chair. Just wanted to turn to a main provision of the Bill 31, which is Indigenous governing body. Could I ask, through you, Mr. Chair, to the Minister, what is the government's current interpretation as to what an Indigenous governing body is?
Minister.
Thank you, Chair. So for the sake of not rewriting definitions that have already been written before, I want to confirm that the Indigenous, our definition in the EDMA of the Indigenous governing body is the same as in Section 1, Subsection 1 of the Declaration on the Rights of Indigenous Peoples Act. So it's consistent with the Declaration Act of BC.
Member for Vancouver Langara, follow up.
Thank you, Mr. Chair, and certainly, as discussed in our committee review to date, this term Indigenous governing body is utilized throughout the Bill 31. And as we get into Part 3, agreements with Indigenous governing bodies, for example, that is certainly a very important part of the bill, at least as it relates to First Nations. The Indigenous governing body definition is utilized here, and as the minister confirmed, is certainly, as you would expect, consistent with Bill 41, or back in 2019, which is now the Declaration on the Rights of Indigenous Peoples Act. What I'm asking, though, Mr. Chair, through you to the minister, is for the purpose of this Bill 31, what constitutes an Indigenous governing body from the government's perspective? Meaning, what is the level of governance structure that is expected by government from a First Nation or another Indigenous nation or community in order to constitute itself as an Indigenous governing body for the purpose of this act?
And member, I'll just ask if you want to continue, just raise your hand virtually. Let me know after the minister responds, or just somehow indicate to the chair. Thanks very much. Minister.
Thank you so much. So in Section 1, subsection 1 of the Declaration on the Rights of Indigenous Peoples Act, Indigenous governing body means an entity that is authorized to act on behalf of Indigenous peoples that hold rights recognized and affirmed by Section 35 of the Constitution Act 1982, and consistent with the Declaration Act. We, as the BC government, do not determine who is or is not an Indigenous governing body. Those authorizations are done by Indigenous peoples and the communities themselves.
Member from Vancouver Langara. Member, you're on mute.
Well, just breaking that down, could I just take the last part of it, Mr. Chair? What level of authorization does the government of BC need to see from authorization from an Indigenous nation or an Indigenous governing body?
Minister.
Thank you so much. So, the Declaration Act Secretariat does have a guidance document. It is called the Indigenous Governing Bodies in the Declaration on the Rights of Indigenous Peoples Act. That's the guiding document. And within the guiding document, it notes that authorization should be read as being pursuant to Indigenous legal traditions, processes, and standards consistent with the UN Declaration Act, or pardon me, consistent with the UN Declaration, that are undertaken as part of a nation's expressing, rebuilding, and implementing their governance systems. So that is the standard that we would also follow under the EDMA.
So in
Member for Vancouver
utilizing-
Langara.
So, and thank you, Mr. Chair. In utilizing the guidance provided by the Declaration Secretariat, as the Minister just summarized, Mr. Chair, can I ask through you, Mr. Chair, to the Minister, what level of authorization, though, is required in order to be demonstrated by the First Nation in question, and what form of proof is there around that level of authorization having been achieved?
Member, I'm just going to mention that the minister has mentioned the definition of an Indigenous governing body, which is the same as it is in another piece of legislation, the Declaration of the Rights of Indigenous Peoples Act, which is another piece of legislation. If you can explain to the chair how this is relevant to Bill 31, given that you're asking questions about another act, and you've had a few times at it, and I think the minister has responded. We're welcome to continue, but this is drifting to the other act. Do you want to explain to the chair, member?
Happy to take this opportunity to explain to the chair. Mr. Chair, if you look at the definition of Indigenous governing body in Bill 31, it says Indigenous governing body has the same meaning as in Section 1, Sub 1 of the Declaration on the Rights of Indigenous Peoples Act. That's the reason why, Mr. Chair, I'm referring to the Declaration on the Rights of Indigenous Peoples Act. It's the reason why the minister in response referred to the same act and referred to the guidance from the Declaration Secretariat that's been set up by this government to implement the Declaration on the Rights of Indigenous Peoples Act. So I hope that helps the chair.
I'll invite the minister to respond, but however, this is on definitions, and the minister has made it very clear what the definition in this act is. So the minister can respond if she chooses, but that has been answered. Minister.
Yeah, thank you, Chair, for that. If I may, yes, so the EDMA does rely on the definitions that have been set out by the Declaration Act. The processes, the procedures that flow from that, we follow. And so the EDMA does not make any changes. And I think that the Chair's point about the questions being really more about the Declaration Act than this Act are valid, given that we do not in this Act make, I guess a lot of the questions probably would have been better answered through the Declaration Act debate, which we are not right now. So we don't have anything further to add at this point.
Member for Vancouver Langara.
In my second reading speech, I referred to the fact that this Bill 31 is significant land-based legislation in part with First Nations, and that under the Declaration of Rights of Indigenous Peoples Act, which was implemented 4 years ago in 2019, this piece of legislation that comes forward by this government is their next step forward to deal with the jurisdictions, the shared jurisdictions between First Nations, local authorities, the government of British Columbia as it pertains to emergency management and disaster recovery under Bill 31. So it's very important to understand for First Nations and Indigenous communities how the definition of Indigenous governing body is being utilized under Bill 31. So the appropriate place to have the discussion around thresholds of application of that term as it pertains to Bill 31 throughout the bill is in the definitions. Otherwise, Mr. Chair, we will be having this discussion every single time Indigenous governing body is utilized in this bill. This is the appropriate juncture to have this discussion. There are other ways to have this discussion, certainly. But the minister, in bringing forward this bill, needs to look to her team around her, as I've given indication on in my second reading speech last week, to ensure that we at the committee stage here, with the member of Caribou-Chilcotin, the member from Skeena, and other members of our caucus, the third party, the fourth party, whoever wants to participate in this committee debate, to have a good understanding, because this really does go to the heart of the relationship of the province of British Columbia with First Nations and Indigenous peoples in our province as it pertains to emergency management and disaster recovery. And so it's important to understand how this government is utilizing the Indigenous governing body's definition as it relates to First Nations and Indigenous nations and communities in our province. That's the reason why I've asked the question to the minister about how this definition is being utilized by this government, because there's significant weight put on that term in this bill. Meaning, if a First Nation or Indigenous community is not determined to be an Indigenous governing body, we will have that discussion other than treaty or NISHKA, of course. But if we're talking about some other First Nation that's not an Indigenous governing body, I think we need to understand how emergency management will pertain to them too. But this is an operative term because it is there embedded throughout this bill, that it's important to have a thorough understanding as to how this government is utilizing this term as a gating mechanism. Those are my words for the application of Bill 31.
Minister.
Thank you so much, Chair. So I'll try to give this a shot again, hoping that we'll be able to provide further clarity. So again, the EDMA relies on the Declaration Act's definition of Indigenous governing body. It does not, deviate from that. In addition to the Declaration Act guidance that I previously read in, I would just reaffirm that the Indigenous peoples have been governing themselves for thousands of years. The processes and traditions within them for establishing what might be their IGB will differ significantly between communities. Our interpretation of the interpretation of the act that we use basically is in deference to their processes and their traditions and the way that they choose as peoples and communities to establish who their IGB might be. I think in most cases it will be very clear. There may be some situations where the conversation is less clear. We would then likely go to the Ministry of Indigenous Relations and Reconciliation or the Declaration Act for some guidance, but generally speaking, the BC government, so our government, would not be the arbitrators or the adjudicators of what is and is not a Indigenous governing body that's been authorized by the community. So that's certainly something that we defer to the communities themselves. And pardon me, I'm thinking perhaps that if the member has further questions on this, given that we would likely take guidance from the Declaration Act Secretariat and the Ministry of Indigenous Relations and Reconciliation, I would be happy to make a connection for the member with the Minister of Indigenous Minister of Indigenous Relations, thank you. It just fell out of my head. The Minister of Indigenous Relations and Reconciliation to have a further conversation on this, if that would be helpful to the member.
Member for Vancouver Langara.
Thank you, Mr. Chair. And certainly I've had the discussions with the minister responsible for Indigenous Relations and Reconciliation, both the former minister and the current minister, on the record over the last 4 years. And certainly, as most recently, in recognition of the Haida Nation, for example, that was the first piece of legislation in the province of BC that legislated into law the recognition of that nation, and obviously as so recognized as an Indigenous governing body. We've seen other examples, of course, with the Tahltan, as they've entered into a Section 7 agreement under the Declaration of Rights of Indigenous Peoples Act with this government a year or two ago. And of course, to the minister's point, Mr. Chair, in terms of the Wet'suwet'en peoples, there is an ongoing process between hereditary and electeds and the community there, both with the federal government and the provincial government, as to what the governance is for that nation. I also know, though, if I can ask through you, Mr. Chair, to the minister, in terms of specific examples that would apply to this bill, let me ask this first from a procedural point of view. As the minister and her ministry addresses emergency management plans, recovery plans, and the other requirements set out in this bill for an Indigenous governing body, does the ministry then presumably makes its own determination as to who they're dealing with in terms of Indigenous governing body? I think the minister is suggesting, of course, that there might be, where necessary, assistance provided by the Ministry of Indigenous Relations and Reconciliation. But the ministry, her ministry, though, Mr. Chair, is equipped, though, to address Indigenous governing bodies. I just want to confirm that that is the case.
Minister.
Thank you, Chair. I was wondering if the member might be able to restate his question, just for clarity.
Member.
My question is really on the basis of the minister's response previously to suggest that I should go speak to the Minister of Indigenous Relations and Reconciliation. My question relates to this ministry when it is through the course of this Bill 31, relying on the term Indigenous governing bodies, that this ministry is equipped to address Indigenous governing bodies and make that determination and process that they have set out in this bill, and that there is not a need to turn to the Ministry of Indigenous Relations and Reconciliation every time a First Nation comes forward and presents themselves as an Indigenous governing body.
Member, I'll just remind you that we are, I think, drifting into the other act, and while the chair completely understands your question, the minister has answered the question under definitions, what the definition is, and I believe, if I'm getting it correct, member, you're looking for a mechanism to explain the mechanism as opposed to the definition. But we'll certainly let the minister respond. Minister.
Thank you so much, Chair. So to the member's question, yes, the Ministry of Emergency Management and Climate Readiness is capable of I guess, establishing relationships with Indigenous governing bodies. We expect in the vast majority of cases that Indigenous peoples, Indigenous communities will identify their Indigenous governing bodies, and we would certainly take them at face value. Where there are conflicts or challenges that maybe require a bit of more nuanced navigation, those are the cases where we would go to the Ministry of Indigenous Relations and Reconciliation, or perhaps the Declaration Act Secretariat for guidance. We don't expect that to be the majority of cases, though.
Member for Vancouver Langara.
Thank you, Mr. Chair, and I appreciate the response and that just addresses how this ministry would deal with the term Indigenous governing body. It's what one would expect, at least in terms of the ministry being able to do this. That's why the term Indigenous governing body, even though it's under a different act, is a definition that needs to be understood, Mr. Chair, by all members of this government, as the minister just confirmed. That would be the expectation, that when there's questions around Indigenous governing body, that the questions are not merely referred to the Minister for Indigenous Relations and Reconciliation, that this Declaration of the Rights of Indigenous Peoples Act is of such a broad sweeping scope that it cuts across all of government, including the Premier of our province. And that direct nation-to-nation relationship, of course, we know is important and fundamental. But that's why, even though this definition, I mean, quite frankly, the cross-referencing that happens in legislative drafting happens, I get that. But, you know, this definition could easily have said the actual definition, which is spelled out in the Act. And we would still be having this discussion without having to refer to the Declaration of Rights of Indigenous Peoples Act. So regardless of where it is, by virtue of the fact that it is cross-referenced and incorporated by reference in this definition, that's the reason why we're having this discussion. Having established that, Mr. Chair, I'd like to ask through you, Mr. Chair, to the Minister, when a tribal council presents itself as an Indigenous governing body under this Bill 31, what, and I presume, by the way, of course, that even today, there are disaster recovery situations where tribal councils are involved, and there are understandings or agreements relating to that. So let me reconfirm that first. I mean, this can be a fairly straightforward discussion. First of all, that her ministry does have existing arrangements relating to emergency and disaster recovery with tribal councils. And if that's the case, again, if the minister could state what level of confirmation is typically required by the tribal council to provide in order to demonstrate that they are an Indigenous governing body.
Minister.
Thank you. So we do, EMCR does have relationships and does work with tribal councils in some areas of the province. And in the case that I'm thinking of, the way that we had determined, or rather the way it was communicated to us that the tribal council would be acting on behalf of a First Nation, was that we received a letter from the First Nation identifying the tribal council as the body through which they wanted us to work with on a number of issues, X, Y, and Z. And so I think that it's fair to say that the default relationship really for a government is nation to nation, with the nation's the individual nation's governing body. But in those cases where a nation identifies to us that they would defer to a tribal council for the purposes of emergency management work and for communicating with us on issues relating to the Emergency and Disaster Management Act or protocol agreements or so forth, then we would take that take them at face value. And in some of the examples where we do work with tribal councils, we have received letters from the nations identifying the tribal councils as the body through which they wanted us to work with. So that's an example of, I suppose, an authorization that we've received.
Member for Vancouver-Langara.
Mr. Chair, and thank you to the Minister for that response. Just to continue on from the framework response that she provided, just to clarify, the level of engagement with EMCR with a tribal council recognizing the minister's comment and reference as well to recognition that the relationship is with the nations themselves as rights and title holders. Her ministry representing this government in terms of their level of involvements with a tribal council as an Indigenous governing body, as contemplated in this Bill 31, would suggest that there's, how does the ministry manage that relationship with the tribal council as opposed to the underlying nations that are giving some indication to the ministry or the government that the tribal council is representing them? Is there direct channels of discussion or relationship or engagement that is also expected under this bill vis-a-vis a tribal council?
Minister.
Thank you, Chair. So it is possible, our obligation as a government is to have a relationship nation to nation. And there are cases, certainly, and we anticipate there will be cases where a nation may indicate that a tribal council or another body is intended to act as the Indigenous governing body for them, for the purposes of emergency management. However, it is not necessary for a First Nation to cede all of their emergency management relationship to the Indigenous governing body. They may indicate that some elements of emergency management they would prefer to keep within the nation, and others might be deferred over to the Indigenous governing body. It's very case by case. I'll also acknowledge that certainly when leadership changes, so if there's an election or other transition of leadership, that relationship may change again, and those protocols may change again. And so this is part of the, I think we do have several sections later on agreements with Indigenous governing bodies, and we can certainly dive deeper into those kinds of scenarios and intentions there.
Member for Vancouver Langara, there it is. You do have another question. Go ahead.
Thank you, Mr. Chair. And through you to the Minister, thank you for that response. It's helpful, certainly. And I just wanted to give the Minister one more opportunity here because she is getting to the point that I'm really asking a question about, which is that relationship, government, nation to nation. So certainly between the tribal council and the nations that that council represents, there would be some sort of understanding and arrangement between the tribal council and the nations. The minister, Mr. Chair, is acknowledging that, having said that, that there would be still a recognition of that direct relationship with the nation involved, and that there may well be certain areas of jurisdiction where that nation has not delegated, so to speak, to the tribal council a level of authority or representation right to government of BC. So I'm just asking through you, Mr. Chair, to the Minister, and I appreciate the Minister's willingness to discuss more detail scenarios, and there are scenarios certainly, but just by way of principle at this juncture, just on the definition, in terms of how Indigenous governing body is utilized here, does the Minister, is it her view that her ministry would ensure in those situations that the ministry maintains some sort of direct relationship with the underlying, so to speak, the nations for whom the tribal council is representing? Is there an approach or a protocol within the ministry that ensures that that is the case?
Member, the question of definition that the minister has answered that. You have asked a more specific question, which the minister has provided a response to, and has also indicated that there will be further sections of the bill where your line of questioning could also be relevant. However, we'll let the minister respond if she chooses to this, and then I'd ask the member to continue with his line of questioning. Minister. False alarm. Minister.
Thank you. So I'll answer briefly, and then we can get into some of the further discussion later on in the section. But to the member's question, yes, it is our intention to maintain some kind of to maintain relationships on a nation-to-nation level with all nations, unless they have indicated that they do not wish for that relationship to be nation-to-nation. And I'll offer that we have had some examples where a nation has, in fact, directed all communications relating to emergency management to, for instance, a tribal council, and we have also seen that that guidance or that I guess that guidance from the nation evolve with different leadership as well. But yes, so the answer is yes.
Member for Vancouver-Langara.
So thank you, Mr. Chair, and thanks to the Minister for the response. And just at the suggestion of the Chair, I will just move to a more specific question relating to Indigenous governing body. In my second reading speech last week, I referred to, and I think even in this committee stage, I referred to the letters written between Métis Nation BC and the province of British Columbia, her counterpart, colleague, Minister of Indigenous Relations and Reconciliation, May 12th and May 30th letters. I would say that if the Minister hasn't seen that letter, it does clearly indicate that it's the view of the Ministry of Indigenous Relations and Reconciliation that MNBC, Métis Nation BC, does not have the status or authority as an Indigenous governing body under the meaning of the Declaration Act, and that this is informed by the Ministry's understanding that Section 35 rights are held collectively, and therefore an Indigenous governing body under the Declaration Act must be authorized by the proper rights holding collective. In view of this government's latest position relating to Métis Nation BC, the majority of this bill does not apply to Métis peoples as represented by Métis Nation BC. Is that correct?
Minister.
Thank you so much, Chair. So there are a few, I guess I can provide a response to how we're viewing Métis people and Métis in context of EDMA. So first, the province recognizes that diverse Indigenous peoples, First Nations, Métis, and Inuit have distinct rights and interests in BC. And At the same time, that our relationship with MNBC varies from our relationship with First Nations, as there are no existing land, water, or air-based Métis rights or associated jurisdiction in BC that triggers the same kind of Crown obligations that are owed to First Nations under Section 35 of the Constitution Act. That being said, the experiences and needs of Métis people can be considered in the application of the Act, as they are Indigenous peoples. So the definition of intersectional disadvantage, for instance, includes consideration of Indigenous identity, and this can include consideration of a person's Métis identity. This provides an opportunity to consider the ways in which Métis people may be uniquely or disproportionately impacted by emergencies. I will also note that the Métis Nation, BC, was engaged during the development of the EDMA as well.
Does the member for Vancouver Langara?
Mr. Chair, and I appreciate the minister's response. And just to clarify, certainly it is also the view of this government as set out in Minister of Indigenous Relations and Reconciliation letter to MNBC dated May 30th that the province agrees that Métis people in BC have non-site specific Section 35 rights. So there is recognition by this government of the non-site specific Section 35 rights of Métis peoples in British Columbia. But MNBC, Métis Nation BC, is not viewed by this government as having the status as an Indigenous governing body, even with respect to those non-site specific Section 35 rights. So that would be my two-part question. One is, presumably the relation between the government and Métis Nation BC is being clarified in the minister's letters. But as the minister just referred to, MNBC was involved in the consultation process for this bill. At the time MNBC was being involved and consulted with, was there other Métis people being consulted with directly, or was this ministry looking to Métis Nation BC as the representative body for Métis peoples in British Columbia?
Minister.
Thank you, Chair. So we did engage with MNBC through a technical team that represented MNBC, as well as with regular check-ins with Minister Hooper. In particular, the engagement centered around conversations around cultural safety, volunteers, intersectional disadvantage.
Member for Vancouver Langara.
Thank you, Mr. Chair. I'll ask the minister to clarify, in addition to a response to my previous question, whether there were any other Métis peoples that were consulted with in the context of this bill, apart from representatives, ministers with Métis Nation BC. That would be just a follow-on question, but to the second question for the minister to consider response to, in recognition of the non-site specific Section 35 rights of Métis peoples in British Columbia, and I do appreciate the minister's comment about intersectionality and including any disproportionate impacts on Métis peoples in British Columbia as Métis peoples. Is there a gap, though, for Métis peoples when they don't have a recognized Indigenous governing body that's operative under Bill 31 that's created in the absence of the recognition of Métis Nation BC as an Indigenous governing body?
Minister.
Thank you, Chair. So to the member's first question, we did not There were no other individuals, like Métis individuals, that were specifically targeted for consultation under the Act. And to the member's second question, the answer is no. The vast majority of cases where the term Indigenous governing body is used in the Act is in relation to traditional territories, which do not apply to Métis peoples. Traditional territories or treaty areas. That being said, I can clarify that there is nothing in the Act that displaces the constitutional obligations that government has under to respect Métis, the Section 35 rights of Métis people. So if through the implementation of something relating to implementation of the Act, something does affect Section 35 rights for Métis people, then they certainly would be consulted. And Chair, perhaps I could request a brief recess, if that's all right, or perhaps after the next question, so that we can allow the member to at least ask his question.
Why don't we take a 10-minute recess, and then we'll come back with Vancouver Langara's next question. Committee's in recess till
I now call the Committee of the Whole on Bill 31, Emergency and Disaster Management Act, back to order. We are on Clause 1. Shall Clause 1 pass? Aye. Nay. Okay, sorry, let him just pop out now. Member for Vancouver and Angara.
Thank you, Mr. Chair. And just before the break, we were discussing Indigenous governing body. I just have one few other questions and a similar set of questions for the Minister, Mr. Chair, on this definition. So through you, Mr. Chair, to the Minister, when the ministry recognizes that an Indigenous governing body needs to be determined by the First Peoples involved, the community, the authorizations that are determined there. We know that there are a number of examples around our province where governance discussions and processes are still underway. As acknowledged previously in this committee stage, I've had discussions with the current Minister of Indigenous Relations and Reconciliation about that, including as it pertains to the Wet'suwet'en peoples. So here, as the federal and provincial governments continue to provide time and space and support for the governance process that is still underway with the peoples there, both from hereditary and elected individuals. Through you, Mr. Chair, to the Minister, what happens with that community, the Wet'suwet'en and Indigenous community, while their governance process is continued to be sorted through? Meaning, how does those Wet'suwet'en peoples get protection or involvement under this Bill 31?
Minister.
Thank you so much. So thank you so much for that question and allowing us the time to deliberate as well. I think that the member has touched on an example of a situation where we would certainly need to consult with the Ministry of Indigenous Relations and Reconciliation. I will say that, I mean, in terms of the intention of EDMA, it is to formalize the requirement to actually establish these kinds of agreements and understandings with First Nations, who is their Indigenous governing body. I mean, right now, under the Emergency Program Act, there is no obligation to have those formalized relationships, although we have been establishing them and reaching out and doing that work in the meantime in order to try to align with DRIPA. So I will say that not all of those relationships are currently established, and certainly this is an example of where we would need to consult with the Ministry of Indigenous Relations and Reconciliation in kind of navigating the situation. What I can offer is what we did this summer. So as an example, this summer when there were wildfires in the region, I was in direct contact with Chief Maureen Loogie of the Wet'suwet'en First Nation. And so that was my contact in the context of this year's wildfire season, but that isn't necessarily, doesn't necessarily mean that will be the practice moving forward. I think certainly following when EDMA comes into royal assent and those obligations take hold, that those kinds of conversations will need to happen.
Member.
Thank you, Mr. Chair. And in the backdrop of all the discussion we've had about Indigenous governing body, I appreciate the consideration of the minister with that response, and also that the minister, Mr. Chair, did broaden response to not just focus on the Wet'suwet'en people's situation, but also made general reference to other work that's being done with other Indigenous communities and nations. I will just turn to three other definitions in clause 1. And the next one is local authority. Local knowledge. Local knowledge is a definition which obviously can be considered in each provision of the Act that where it arises. But just to ask a general question at this stage, in terms of recognition of Indigenous knowledge of their lands, is there any intention that this definition would include recognition of Indigenous knowledge?
Minister.
Thank you so much. This question was actually canvassed by the member of Caribou, Joe Colton, earlier, so I'll provide the same response then, or now as I did then, which is that for the purposes of this legislation, local knowledge is considered to be separate from Indigenous knowledge, although the two can share similar characteristics. So local knowledge being a separate definition from Indigenous knowledge, but understanding that they can have overlap.
Member.
Thank you, Mr. Chair, and I appreciate that you've had to already respond to the member from Caribou Chilcotin about this definition. Just to follow on with the minister's response, Mr. Chair, within this Bill 31, though, Indigenous knowledge what I'm hearing, Mr. Chair, is going to be treated separately from local knowledge, although there's recognition there may be some overlap. So is there, but there's no need to have a separate definition for Indigenous knowledge.
Minister.
Thank you. So there isn't a separate definition for Indigenous knowledge in the definitions list, largely out of respect for, well, recognizing that Indigenous knowledge comes from Indigenous peoples. It is not for us to define what is or is not Indigenous knowledge. And so it's not specifically defined in the definitions section 1.
Member.
Thank you, Mr. Chair. I don't have it with me here, but we will perhaps, Mr. Chair, if you could note for your colleagues, I'd like to come back to this particular provision in a future committee, only because, and perhaps in the meantime, if the team around the minister would like to consider it. My recollection is there may well have been another statute that has referred to Indigenous knowledge. I'm just trying to recollect, though, whether there was a specific definition. I'm thinking about the Protected Areas Act bill, areas around that the Minister of Environment had brought forward in the last year or two, is my recollection. I was looking at that bill for other reasons, but perhaps we can double back on that. But I'll just park that there for now and just move on to another definition, Mr. Chair, and that is specified land. Under sub E of the definition, it refers to land held under Aboriginal title. Could the minister, through you, Mr. Chair, just elaborate on what is intended there to be captured under sub E?
Minister.
Thank you so much. So land held under Aboriginal title, under subsection E of specified land, is land that is subject to an Aboriginal title declaration by the courts, such as the Silcoteen, or potentially in the future established by agreement.
Member.
Thank you, Mr. Speaker. And in terms of sub F, prescribed land would potentially include lands that are under review by the courts or agreement as the two categories under sub E or under treaty negotiations. Is that correct? Or are there any other types of prescribed land? First of all, is that correct in terms of the three types of potential lands that might be prescribed, again, by agreement, by court decision, declaration, or under treaty process? Is that the intention of what a specified land could capture? And if so, why? And then secondly, what other types of land might be captured here under the definition of specified land?
Minister.
Thank you, Chair. Subsection F, prescribed land, was really included in recognition of the way that rights are constantly evolving. And so it's meant to capture potential, I guess, types of I had the term in my head and I've just totally forgot it. Intended to capture land that maybe isn't currently contemplated. So in the member's question around agreements and court decision declarations, those would be captured under subsection E. Treaty processes, that would be captured under subsection B. And so those are not what is intended by subsection F. Rather, subsection F is kind of other, I guess.
Member.
Thank you, Mr. Chair, and appreciate the clarification by the minister. And that's actually what I was asking. I was only, Mr. Chair, referring to those other categories as surmising potentially that that's what prescribed land means. So let me ask then directly the question this way. So for lands that are not yet finalized as part of a treaty, would they fall under a prescribed land or would they fall outside of this act?
Minister.
Thank you. The specific example that the member provided, using subsection F to maybe prescribe land that is currently under or actively under treaty negotiations but hasn't been fully resolved there, that's not what is contemplated for the use of that subsection. I struggle to. I mean, it's a bit speculative, but it sounds, what the member's describing almost sounds as though maybe using regulation to establish an area of land that is under negotiation but hasn't been resolved yet for treaty. I don't know I don't know what circumstance we would use that under, although we can definitely canvass that further under the relevant sections, section 69, 76, and 23 in the context of those sections. I think really subsection F is about creating the space to allow the prescription of land that is not for, I guess, under circumstances that aren't currently contemplated. So it creates the space to recognize that because rights and title and around land are constantly evolving, especially in this in the years immediately following the Declaration Act adoption by the province, and also what we're seeing in terms of all sorts of groundbreaking declarations by the court. I think it's really recognizing that we can't truly. This space is so actively evolving that there may be circumstances that aren't covered by the other subsections, and so we provided a kind of an other section. But that specific example that the member provided for, it isn't our intention to use that subsection for that purpose.
Recognizing the member for Caribou-Chilcotin.
Thank you, Chair. I just, before the member from Vancouver-Langara moves on to another definition, I wanted clarity to the comments that the minister made with respect to item number E, land held under Aboriginal title. I think you referred to land in the Silcotin territory as being included in this item. I just want clarity around the fact, is it the Silcotin or is it the Honeygatine that you're referring to?
Minister.
Okay, so the declaration made by the Supreme Court of Canada in 2014 declared that title is held by the Silcotin Nation, so that's what we were referring to, specifically Silcotin Nation held lands.
Member.
Thank you, Chair. I guess I just want to be very clear on this point, Chair, because the title lands are cared for by the Honeygatine Nation, and they are, of course, Silcotin. But there are many bands that might fall under that Silcotin category, Mr. Chair, and I want to be clear about the lands that we're referring to. So is it the lands that the Honeygatine are caring for, Mr. Chair, or does it involve all of the Chilcotin?
Minister.
Okay, so there is a map attached to the Supreme Court of Canada declaration outlining the specific area. And the member is correct that it does fall within the caretaker area of the Haninkotin. However, the ruling was that the Tsilhqot'in had title over the area.
Member.
Thank you, Chair. I think I just wanted to turn it over to the member of Vancouver Langara again.
Recognizing the member of Vancouver Langara.
I just have one more definition before going on to clause 1 sub 2. And that is the definition around traditional territory. So through you, Mr. Chair, to the minister, can she also elaborate on what's intended to be meant by a traditional territory of Indigenous peoples? What does that extend to?
Minister.
Thank you. So I guess similar to Indigenous governing bodies, we do rely on First Nations to tell us what their traditional territories are, but we generally understand them to be areas where First Nations have historically occupied or used or exercised their rights in. The MIR, Ministry of Indigenous Relations Reconciliation, does keep track of areas that have been identified as traditional areas. And so those are the same areas that we would understand them to be.
Recognizing member for Vancouver and Gera.
Sure, I think that's an example of a definition that we can come back to potentially as it's utilized in a particular provision of the Act. Let me just move on to sub 2 of this clause 1, which refers to consent by an Indigenous governing body. So through you, Mr. Chair, to the Minister, what is the process for which an Indigenous governing body would be asked for their consent for an order or emergency instrument under the Act? And secondly, what form does that consent take?
Minister.
So the legislation doesn't set out the specific process for how an Indigenous governing body would consent. However, that is the purpose of the advanced planning and agreements that, that we would set out that process ahead of an emergency. So for instance, through a coordination agreement or any number, other type of agreement that is enabled through EDMA, those kinds of processes would be clarified in advance. But for the purposes of providing a little bit of color, I guess, in the types of consent processes that could take place, they could be, very substantial consent processes where the circumstances are appropriate for that that to take place, like if you have enough time in advance to figure that out, or if you're working on mitigation plan, then you could have a more substantial consent process. Or it could also include, like if you are in the midst of an actual emergency response with not a lot of time, and time is of the essence, and it could take the could look like just even a phone call. I mean, all of this would ideally, the intention is that these kinds of processes would be established up front through the agreements, and yeah, that's probably it. So the main answer is we would establish it up front through these coordination agreements or other types of agreements enabled by EDMA.
Member.
Appreciate the minister's response, and obviously we're just trying to get a good understanding at this juncture as to how this framework around emergency management, disaster recovery will work with First Nations. And so in view of the minister's response, Mr. Chair, two-part question again. Is it the intention of the ministry to, because there's waiting on coordination agreements and other Part 3 agreements or other agreements as contemplated under this bill, is it intended that the ministry will enter into a process to enter into agreements with each of the 204 First Nations? And secondly, in the interim period, in the absence of a particular agreement with the nation, a particular nation, how will their consent process work if it's not spelled out in an agreement?
Minister.
I think that the answer to the member's question is in the clause itself, which is that an order or emergency instrument made under this act does not apply to an Indigenous governing body unless the Indigenous governing body consents, and thus the default or the interim provision prior to an agreement where an Indigenous governing body does consent is that the order or the emergency instrument made under the act does not apply to the Indigenous governing body. I will perhaps provide an example of how this might play out based on something that happened during this year's wildfire season, which was around the emergency travel and accommodations order. And so when it became clear that we required an emergency order to restrict travel for the purposes of using short-term accommodations, I made calls to leadership of each First Nation with communities within those areas that could be affected by the travel order, and asked them directly whether they wanted to be a part of the travel order or not. And if in First Nation leader said no, then we would have carved them out of the maps of the order. However, in this case, all of the First Nation leaders agreed to be a part of the order, and that's how they ended up in the order. But we would not have included their communities in the order if they had asked to be carved out of it. Sorry, Chair.
Madam Minister,
Sorry, perhaps I should have been more clear. We would not have included the Indigenous community within the order if we had not received that consent. So the default, for instance, there was a time when I couldn't quite reach all of the First Nations leaders, and so then the default would have been to leave them out of the order, but then we did manage to reach them, and then we included them with their consent.
I just want to confirm that whether the member of Vancouver Langara is asking the clause 1 to be stood down?
No, I mean, it was a more technical point that I just mentioned on the definition of local knowledge, but the bill as presented doesn't include a specific definition of Indigenous knowledge. It will be, given that we're not done with the bill, I think if the ministry took a different view on this after we had more discussion by virtue of an amendment, I presume they could still amend a section if the bill's not been approved yet. If that's the case, then we don't need to stand down clause 1.
Seeing no further questions, shall clause 1 pass?
Aye.
So order, shall clause 2 pass? Recognizing the member of Caribou-Chilcotin.
Thank you very much, Chair, and thank you for the answers provided under Clause 1. Moving on to Clause 2, under item number C, 1C, the bill quotes foster collaborative approaches to the matters of mutual interest. I wanted to understand what the mechanisms are for that collaboration, when it would occur, and who it might be referring to.
Minister.
Thank you so much. So one thing to note about this entire section is that they're intended to demonstrate broad principles for emergency management. And so they aren't necessarily meant to be specifically tied to specific procedures, but in answer to the member's question, examples of kind of fostering collaborative approaches to matters of mutual interest might include the use of CEMAs or collaborative emergency management agreements, or consultation and cooperation requirements that are discussed throughout the legislation, consultation and coordination agreements, or the use of MAGEMOs like multi-jurisdictional emergency management organizations. So in principle, the intention is to really foster collaboration as much as possible through whether it is through some of the tools enabled through EDMA or beyond.
Member.
Thank you, Mr. Chair, and thank you for that answer. In definitions, we spoke at great length about collaboration and how both communities and First Nations and, of course, individuals might have an opportunity to be a part of that going forward. I guess my concern on this is the broadness. I mean, I think that British Columbians, no matter what part of British Columbia you might represent, whether you're a rancher or a forester or whoever, certainly have much to say about emergency management in this province. And I hope that you know, there are obviously documents that were provided under our definitions section that led to some of the collaboration. We talked about collaboration with First Nations a great deal, so I can appreciate that this is a framework, but you know, I don't necessarily want to introduce another question on this topic, but I just want to say that this is probably the most important thing that I've heard from all walks of life, from all local governments, is that opportunity to have fair comment with ministries like this one. So that they are a part of the process. I'll move on to item 2B, which is investing in the measures necessary to reduce the risk of emergency, etc. I want to understand better what that investment is, what it looks like, and I further want to understand how you will enhance the economic situation in this province through that.
Minister.
Elaborating on what I had said earlier about the principles being really just the principle section is intended to establish or make clear the approach to emergency management that the government is taking and what we are basing our approach on. It's reflective of the UN Sendai framework on disaster risk reduction, and so subsection B speaks to priority 3 of the UN Sendai framework on disaster risk reduction, which is effectively to says that in order to reduce the risk of disasters before they happen, to mitigate the impacts of disasters before they happen, we need to be investing upfront and doing more of that work. Now, legislation like this cannot prescribe or dictate the spending of government, so that's why it's sitting here in the principles section. It doesn't directly relate to specific dollar amounts, but I can describe some of the investments that are that have been made so far that would align with this, and we would hope would continue into the future. So, as an example, the Community Emergency Preparedness Fund is investing in disaster risk reduction. We added Sorry, just thinking about the numbers. Earlier this year, we added $180 million to it for a total of $369 million in the fund. That fund is provides funds directly to local governments and First Nations for a number of emergency preparedness and mitigation activities. The most substantial stream under that funding in terms of dollar amount would be the Disaster Risk Reduction Climate Adaptation stream. It provides 100% of the cost of eligible projects to a maximum of $5 million for small-scale structural activities. And some of the projects that we have seen come out from that stream include, it could be dike upgrades, it could be erosion control measures, could be projects that provide more room for the river to absorb peaks in river flows. We have seen other projects like communities in tsunami zones have kind of created plans for vertical evacuation structures. Some of the other projects that have been funded through the Community Emergency Preparedness Fund include projects that improve evacuation planning, that improve planning for extreme heat events, that provide funding for flood risk assessments and those sorts of things. So that's an example of the kind of investment that helps to mitigate the impact of disaster before they happen, kind of more upfront.
Member.
Thank you, Chair. A bit of a follow-up. So that is exactly what I was looking for as far as the answer was concerned. I guess I can appreciate that the minister has contemplated many of these types of things. And while I understand that it is a principle, the minister was clear in explaining a fund of $180 million and a number of other projects. Is it the intent of the ministry through Bill 31 to manage many more of those types of projects? So in other words, I know that we'll get later to understanding what ministries may look after which disasters, but it does sound like the ministry will take an overarching role with respect to funding projects, for instance, thinning of forests and those types of things that the minister just outlined. I'm just wondering, Mr. Chair, if we could expect more of that in the future from this ministry.
Minister.
Thank you. So I think the principles are really important, and I'm glad that the members raising questions around them so that we can kind of talk through them more. I would say that to your question, this principle. The principles are an expression of government's priorities, and one of the government's priorities is to do more upfront investment on the preparation and mitigation side of things, because we know that in emergency management, a dollar invested upfront is worth $10 or more in response and recovery. And the entire structure and framework of the EDMA prioritizes preparation and mitigation in addition to response and recovery, rather than just focusing on response and recovery. And so the framework is intended to enable the work that then enables the kinds of investments that we need to make upfront. So if you look at the UN Sendai framework on disaster risk reduction, the first priority of it is to understand the risk, that you can't manage a risk that you don't understand, that you don't measure. And so risk assessments are a big component of the work that is required under the EDMA of various regulated entities. And once you have understood this risk, then you can develop mitigation plans for them. And when you have mitigation plans, you're able to inform where investments are. And so through the EDMA, I would say, we're creating the entire framework that puts greater emphasis on that upfront work, and it actually enables it, whereas under the EPA, because preparation and mitigation aren't considered in the EPA, all of our spending ends up on response. And I mean, that being said, I know that the ministry and other ministries and different agencies and local governments have certainly been looking more to preparation and mitigation in recent years, but it's not actually really enabled by the EPA, whereas it will be enabled by the EDMA, kind of that kind of thinking.
Recognizing the member for Vancouver, Langara.
Turning to another principle that's set out in Clause 2, Sub D, relating to cultural safety. If I could ask the minister to elaborate on what's intended here as a principle and what it captures, including in respect of the responsibilities and legislation under the Heritage Conservation Act.
Minister.
Thank you. So this principle speaks to the need to consider cultural safety as part of emergency management plans. Cultural safety can be defined as an outcome based on respectful engagement that recognizes and strives to address power imbalances inherent in the disaster response system. Some examples of where I've seen cultural safety integrated as part of emergency management and response plans is reception centers that have rooms for smudging for Indigenous elders. Some of the partnerships that we have had with, as an example, Tecumlips to Sewetmik on their evacuee center, really a lot of that their work focused on providing a culturally safe environment for Indigenous peoples, and so that's what that principle speaks to. Perhaps a member could elaborate on his question in terms of the Heritage Conservation Act. It's not directly linked to the EDMA, so perhaps some clarification on the question would be helpful.
Member.
And appreciate the minister's response, Mr. Chair. Generally speaking, in terms of the Heritage Conservation Act, to the extent, obviously, that act deals with cultural artifacts, archaeological materials important to Indigenous peoples and First Nations as well. In the context of emergency management and disaster recovery, this principle then does not bring in that other piece of legislation. Is that what I'm hearing the minister say? Is that correct?
Minister.
Thank you. So while this particular principle does not, it speaks to cultural safety in the way that my previous answer provided, as opposed to artifacts or heritage sites, the objects or sites of heritage value is incorporated into the EDMA and is in fact a part of the definition of an emergency, found in the definition of emergency.
Seeing no other questions, shall clause 2 pass? Oh, no, never mind. My apology. Recognizing member of Vancouver and Niagara.
Thank you, Mr. Chair. I just wanted to ask I'm just going to ask my next question, but perhaps I could also ask the minister just to clarify the last part of her response to the last question. If she could just restate it for me, just so I'm clear on understanding what she means in terms of the definition of emergency. But my next question pertains to clause E. When we're talking about recognizing the inherent right of self-government for Indigenous peoples, including the authority to make laws in relation to emergency management, those laws that are contemplated in this principle, I just wanted to have an understanding of the scope. Do those laws apply to whom and to what lands?
Minister.
Thank you. So I'll start with the second question first. So again, this principles clause basically acknowledges that that First Nations do have inherent rights to law and have their own lawmaking authority. We do not set out the scope or breadth of those laws. They are their laws, not for us to manage or to dictate. Or put boundaries around. However, again, this is a principles clause, and so how this principle is reflected throughout the EDMA is through the mechanisms that we have enabled in the EDMA to work with First Nations, given the recognition of their ability to, of their rights to make their own laws. So for instance, through coordination agreements, recognizing that emergency management is a shared space, and if you've got multiple authorities creating laws around emergency management, then you could potentially get into situations where you have conflicting laws on the same land base. And so the use of coordination agreements is one of the mechanisms through which we clarify what laws and authorities apply, so that we eliminate the chance of those conflicts from happening during an actual emergency situation, so that we're actually working them out ahead of time. Other mechanisms are found throughout the EDMA through the various types of agreements that are provided for. And then, give me a second, catch my breath. And then for the member's first question, so to clarify, back in Section 1, under the definition of emergency, it defines an emergency as a state that, subsection B, requires the prompt coordination of action or the special regulation of persons or property to protect, and then subsection II, the safety of property or of objects or sites of heritage value. So it's part of the definition of emergency. So the two parts, so the definition of emergency has two parts. It's the result of any of the following, blah, blah, blah. And B, requires the prompt coordination of action or the special regulation of persons or property to protect, so forth. And one of the things that you could be protecting is objects or sites of heritage value. I can go through that again because the blah, blah, blah maybe didn't make sense, but it's in the definition there.
Member.
Thank you, Mr. Chair, and I do appreciate ministers, both of the ministers' responses. I think the first response relating to the shared space is certainly an area that I know the member from Carrick-Chilcotin and myself and others will want to fully explore, because those coordination efforts and understandings are going to be very important. And so I recognize what the minister is saying in terms of this principle, which is the reason why I had asked to at least give the minister an opportunity to elaborate on it. I think in terms of the emergency clarification on that, I understand certainly the minister's point in terms of sites of heritage value. And I appreciate that perhaps the minister just clarify, given that we've already gone through that definition, but just in view of the response, Mr. Chair, that the minister provided, to what degree then, because an emergency is defined as including sites of heritage value, and I was interpreting this principle as extending to heritage sites in terms of promoting cultural safety, but the minister is more focused, let's say, on the definition of emergency as really capturing Heritage Conservation Act. So how does that act then, and that piece of legislation, get coordinated with Bill 31?
Minister.
Okay, so I think maybe so there isn't a direct tie between the EDMA and the Heritage Conservation Act, as in the EDMA doesn't reference the Heritage Conservation Act, but perhaps it would be helpful to elaborate on what could be considered a site of heritage value. And it could be a site of heritage value as defined under the Heritage Conservation Act, but it could also be a site of cultural or heritage value that has been identified by a First Nation. And could be contemporary as well. So a First Nation could say that they have a particular arbor that is very important to them culturally and has heritage value. We have also heard from First Nations who identify certain natural spaces as having important heritage value as well. Traditional fishing locations and so forth. So it could be any number of things, but the important part of all of this work is to identify those sites in advance so that they can inform emergency management plans going forward into the future.
Member.
Thank you, Mr. Chair. And I just have one more question at this point, but just also to say to the minister, I appreciate the response. And as we look at emergency in the course of emergency management plans, perhaps we'll come back to the heritage component of it, and as we talk about examples, which are helpful to do. In terms of sub F, which refers to Indigenous advice, input, and stewardship activities, recognizing that this is a principle, if the minister could just elaborate on the importance of this principle in the sense that is this a change in approach in any sense, that there hasn't been recognition of Indigenous advice, input, and stewardship activities? So does this elevate that level of importance?
Minister.
Thank you. So the current Emergency Program Act is completely silent on Indigenous peoples and First Nations, their inherent rights and everything related to Indigenous peoples in emergency management, whereas this principle is reflected throughout the EDMA through the recognition of Indigenous knowledge, the requirements for consultation and cooperation, and the recognition of First Nations as decision makers in the emergency management context.
See no further questions. Shall clause 2 pass? Aye. Shall clause 3, so ordered. On clause 3, recognizing the member for Caribou Chilcotin.
Thank you very much, Chair. Just a couple of quick questions on this clause. Under item 1, D2, it suggests that we're going to restore the safety of property or of objects or sites of heritage value. I just wanted to get a better understanding of what that would suggest.
Minister.
So Section 3 describes the emergency management phases. They are not prescriptive steps for how each phase is carried out, but rather descriptions of what would fall into each phase. And so later on in the EDMA, as we're going through the sections where where a section might or a clause might refer to a certain phase, if there's ever any question of what kind of activities would fall under that phase, we could refer to Section 3 for it. So for instance, if there was an activity that was the restoration of property or of objects or sites of heritage value, according to Section 3, this would come under the recovery phase of emergency management. And if there were questions about spending under various phases and what kind of activities would fall under that phase, Section 3 would describe the kinds of activities that would fall under that phase.
Member.
Thank you, Chair. Unless I'm misunderstanding, I can appreciate what the minister is saying, but this clause actually, or this phrase says, restore the safety of property, and I'm unclear as to what that means with reference to how will the minister restore safety of those properties?
Minister.
Perhaps some examples might be helpful. So as an example, during an emergency, let's say your home is flooded out, it may render the home unsafe to actually return to, and so restoring the safety of that home would be considered a part of the recovery phase of emergency management.
Member.
Thank you, Chair. So if I'm hearing the minister correctly, then this would also involve private property then?
Minister.
Yes, it describes the kinds of activities which would fall under various phases. So under the response phase, that is where we are actively responding to an ongoing emergency to prevent it from, or to prevent and reduce the adverse effects of that emergency. It might be evacuating people from their homes. It might be putting up flood barriers to manage the flood waters, whereas when it comes to getting people back into their homes and ensuring that their homes are safe, that would fall under the recovery phase of emergency management.
Member.
Thank you, Chair. And those are all tasks that this ministry specifically would perform?
Minister.
So once again, the section describes the various emergency management phases, regardless of who is undertaking those actions.
Member.
Thank you, Chair. Can I get a better understanding then of number 3, which is the ministry will increase resilience to emergency. Can I get a better understanding of that, Mr. Chair?
Minister.
Thank you. So again, for greater clarity, the activities spoken of under these emergency management phases are not limited to actions or work that the ministry is doing, but by any entity. And so increasing resilience to emergencies during a recovery phase would be an example of it would be Build Back Better activities. So if you had a piece of infrastructure, a roadway or a highway that has been washed out by a disaster, then in building it back, it should be also built to a higher standard so that its future resiliency is improved. So those kinds of activities. So the activity of building back better following a disaster would also be considered as part of the recovery phase.
Member.
Thank you very much, Mr. Chair. Does that then suggest that the ministry through EMCR will be advocating for that very thing, Mr. Chair, that Build Back Better opportunity?
Minister.
I think it's fair to say that by signaling through the EDMA that we consider that part of the recovery phase, we do believe that it is an essential part of emergency management, that we do be building back better. It is aligned with the UN Sendai Framework on Disaster Risk Reduction, which also emphasizes the need to build back better. And in terms of the activities that the ministry is going through right now to enable that Build Back Better work. An example would be through our disaster financial assistance or post-disaster financial assistance regulatory engagement that's currently open. We do actually have, part of the engagement is an exploration of what Build Back Better means to stakeholders and partners, and how we can facilitate that through that program.
Member.
Thank you very much, Minister, for that. Then I guess just going to all of the principles that are outlined here, I guess I just want to get a real sense of what the purpose is for outlining these 4 emergency management phases, and what goals does the ministry hope to accomplish with them?
So throughout the entire EDMA, it is the intention of government to incorporate all 4 phases of emergency management into emergency management, being it preparation, mitigation, response, and recovery. Under the current Emergency Program Act, that act is very focused on response and a little bit on recovery. We believe, our government believes that in alignment with the UN Sendai Framework on Disaster Risk Reduction, that a penny of prevention is worth a pound of cure, and that's the approach we are taking. Now, if we are going to incorporate all 4 phases of emergency management into the legislation, it would help for us to be clear about what kinds of activities we believe fall, or what kinds of activities are meant to fall under each phase, so that when we're working through the legislation and you see references to the various phases of emergency management, if there's ever a question about what kinds of activities that phase refers to, we can refer back to Section 3 and have a clear understanding of that.
Member.
Thank you, Chair. Thank you, Minister. So then, is it safe to say that these 4 principles will be a guiding light for all emergencies occurring in our province, and will different agencies like BC Wildfire, will they be expected to work by these 4 principles?
Minister.
Okay. So for clarity, Section 2 outlines the principles. So the emergency management principles are outlined in Section 2, whereas Section 3 is really about, I want to say timing, except that emergency management phases can often overlap. It's really about helping to establish an understanding of what kinds of activities fall under different emergency management phases. It's in the other sections of the Act that we actually put those phases into practice. Section 3 is more of a, I guess, an elaborative section to help clarify what we mean by those various phases, preparedness, mitigation, response, and recovery, when they're referred to in other sections of the bill.
Member.
Thank you, Chair, and I'm getting an indication this might be the last question for the day. I want to understand this because, while I misspoke and said principles, I did mean the phases. So I think that this is an important part of communication between different ministries, different agencies that may be working on the landscape, in the middle of whatever emergency we may be dealing with. I guess what I'm trying to understand is, will this be, will this be the framework for all of those agencies that we might be working with across ministries and across? So when you're talking to BC Wildfire and they say that we are in the response phase, that's going to make sense to everybody that might be involved, whether that's Ministry of Health, local governments, etc. So what I'm trying to understand is, will this be the communication that is used going forward for all ministries and all local governments, First Nations, etc.?
Minister.
Thank you, Chair. So although the EDMA doesn't automatically update the language and terminology of other acts, I believe it is fair to say that, yes, the four-phase approach is the approach that government is taking on emergency management. It is also the four-phase approach is well adopted around the world in emergency management, so it's not new or specific to the EDMA or the BC government. And certainly in implementing the EDMA through different sections that require risk assessments, for instance, the agencies required to put together emergency management plans will be required to do so under the four-phase approach. And so I think it is fair to say that that language will be quite common. It will be common with our partners and other agencies.
See no further questions, shall clause 3 pass? Aye. So ordered, shall clause 4 pass? Aye. So ordered, and on clause 5, ask the minister to move the motion.
Report progress and seek leave to sit again.
Members, the question is that the committee rise, report progress, and seek leave to sit again. Those in favor indicate aye. Aye. Those opposed indicate nay. Motion is carried. The committee now stands adjourned.